Good morning. Good morning. My name is Ronaldo Hilton, the chairperson designee for the New York City Loft Board. Welcome to our November 30th, 2017 public meeting. I will first turn to vote of the minutes in the October 26th public meeting. Are there any corrections or comments to the meeting? The minutes. No. Okay. There are no comments. There are no corrections to the minutes. Yes, sir?
I didn't put this down, but one sentence ends up with leave instead of live or lived.
No, that was last one.
That was fixed.
That was from last month and it was fixed.
Oh, it was fixed.
Yeah.
These are different.
These are different. These are from a different meeting.
This was a second.
I saw I just printed this out the other day.
You did it last month.
You may have
All right, okay.
We had two
All right,
meetings in
thank you.
October. The minutes that we're talking about now are the 22nd,
Okay.
the October 26th meeting.
Okay.
Are there any other comments or concerns? No. So then, Ms. Rivera, could you please hold?
Motion.
A motion.
I'll make a motion.
Mr. Roche.
Second.
Mr. Delaney. Ms. Rivera.
Collins?
Yes.
Mr. Barrett?
Yes.
Mr. Roach?
Yes.
Mr. Delaney?
Yes.
Jefferson Hudson?
Yes.
5 in favor, 2 absent.
Thank you. Ms. Balsam will now do her executive director report.
So the first issue I wanted to talk about is the requirement for a quorum and majority when there are vacancies on the board. So as you know, due to 2 vacancies, the Loft Board currently consists of 7 members. After consultation with the law department, it has been determined that during the period in which the board has its current complement of 7 members, 4 members will constitute a quorum, and the affirmative vote of 4 members will constitute a majority acting on behalf of the board. For most boards, the makeup of the board is fixed by law, but the Loft Board is actually different from other boards. Pursuant to Section 282 of the Multiple Dwelling Law, read in conjunction with Executive Order Number 129 of 2009, the board must have from 5 to 9 members and include representatives of specified interests. Because all specified interests are presently represented and the board has 7 members, it is fully constituted without a legal vacancy. The mayor may change the required quorum and majority by making additional appointments up to a maximum of 9, or by amending or replacing Executive Order Number 129 to alter or fix the number of members on the board. The next issue I want
I just want to get a question.
So if there were 8 members, has there any been discussion? What happens if there were 8 members?
If there were 8 members and all of the specified interests were fully constituted, it would be 5, because the majority would be 5.
Well, that shows the flaw in the thinking, but okay, all right.
Because we actually had that situation where we had 8. So,
Yeah, we had 8 members for a long time.
right.
Okay.
With regard to this, how did this question come up?
It was raised by an attorney.
Raised by an attorney.
Okay.
Therefore, we had to get guidance.
Right, so we saw guidance. All right, next is economic impact of sales of rights. At the last board meeting, the board requested a presentation of different viewpoints as to the possible economic impact of changing the sale of rights rule. So we would like to renew, the chair would like to renew his request that the board members submit names of possible presenters, because we're not exactly sure who to go to for that. So if you could give us guidance, that would be wonderful.
I think, Mr. Carver, you had requested.
Yes, in fact,
In conjunction with Mr. Delaney, we were kind of counting on you guys to give us.
yes, in fact, I have some names in mind, which I will send to you.
Great.
Yeah, thank you.
Great, Mr. Delaney also. All right, thank you.
On on this topic, what exactly are we looking for?
I get information on how it's going to affect owners, tenants, what are the possible ramifications of making this change? It is a big change, and what are the ramifications?
And what kind of people would, do you think, be in a position to speak to that?
I happen to think it would be, one class of people would be the attorneys for landlords and tenants who have been in the field, since almost the start of the Loft law, who have insight into how the change would affect owners and tenants and buildings. There's also some sort of independent, some scholars who work on housing issues. Also, it might be interesting to hear from.
It impacts also on tenants also, right? So we'd like to hear that perspective.
And what are we trying to get people to come here soon? What's the, there's a lot of work to do, so
Yeah.
whether this is
Soon, I don't see this. Do you see this happening before? Let's try to January. Is that right?
Oh, sure.
I don't think it's possible.
Can I go?
Sure.
Just this? On the failure to file the monthly reports for the December 2016 violations, we had 3 additional owners who paid last month, so there are only 4 owners that still owe fines for those. For the violations that we issued in May of 2017, the appeals deadline has passed, no one has filed. We issued 28,000 fines, we collected 6,000. There are currently 22,000 outstanding. We will continue to try and collect those. For the registration renewals, there are 38 buildings that still have not registered. We are working to get those buildings registered. Our unofficial total revenue for October was $53,833. And in litigation, we were served with a petition by the owner of 517-525 West 45th Street. The petition challenges the denial of an extension of code compliance deadlines. That's my report.
And in the buildings that have not, you mean re-registered, right?
Correct, yeah, re-registered.
Renewed their registration.
Filed their
Is that-
annual registration.
Do you know to the extent that that is still a normal range of what happens annually? Or is it better or worse?
I think it's a little worse. If I remember correctly, last year we had more complaints than at this point in time.
following up on that, generally, at some point, we bring
The FOs.
DFOs.
Yeah, I think that'll be January.
Early January.
Yeah.
But that's a little later than has been the case in recent years.
Yeah, last year was later because working on getting it done sooner. But we tried very hard to make it for this meeting, but we missed by just a few days in terms of notice. So there were requirements for how long people have to answer. We don't really want to step on that.
So we
So
would,
we'll do it in January.
not December.
So the meetings in December are really supposed to be rules meetings, and not, because normally the board doesn't meet in December.
Oh, both of them are intended to be.
They're supposed to be rules meetings.
Oh,
So,
I mean, to the extent if we do me, because then Is it possible to bring those?
We could,
to
yeah.
one of those meetings?
Those are, the FO cases are pretty straightforward, and obviously, among other things, since if there's been a change in building management, contact phone number is supposed to be supplied. It seems reasonable to.
Okay.
Okay. We do call people, by the way, you know, they don't tell you. We actually do call them and ask them.
What did they say?
That's it.
Okay, thank you, Ms. Bolton. There are 3 cases on the appeal and consideration calendar. The first case is Alamel Walk at 763 Avenue of the Americas in Manhattan, docket number AD0080. Mr. Clark will be presenting this case.
Thank you, Mr. Chairperson, board members. On March 24th, 2010, owner filed an application for rent adjustment based on code compliance costs for the building, which included legal fees. Loft board staff issued an administrative determination disallowing the legal costs alleged in the rent adjustment application. Owner then filed an appeal challenging the administrative determination. Owner withdrew the appeal. The staff recommends the board deem the application withdrawn without prejudice.
Thank you, Mr. Clark. That was very short. Does anyone have any comments about this case? Any comments? Is there a motion then to accept this case? Mr. Carver, second. Mr. Delaney. Ms. Rivera, could you please?
Mr. Carver?
Yes.
Mr. Robert?
Yes.
Mr. Lewis?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 absent.
The second case is okay. The second case on the agenda is being tabled. It raises some issues about the CVO that the department building is reviewing at this time, and so we're going to table the case of Peter Malera and others at 255 18th Street in Brooklyn, AD 0086, until further notice. The third case, Catherine Laval at 39 Ainsel Street in Brooklyn, docket number R0353. Mr. Ballard, could you please present this case?
Thank you. On March 22nd, 2017, Karen Laval sought reconsideration of order number 4624 based on an alleged denial of due process and an error of law. In the underlying coverage application, 10 plus 6 units filed an application seeking Article 7C coverage for 8 units. The occupants of Unit 1 and what is called the dormant unit were not applicants seeking Article 7C coverage for their units. In the course of the litigation, tenants of 5 units entered into separate agreements with the owner, withdrawing their coverage claims for their respective units with prejudice. Ms. Laval, the last remaining applicant, did not enter into agreement for her unit. In an email dated November 23, 2015, Ms. Laval's prior counsel discontinued the coverage application. On May 5, 2016, owner registered the Laval unit as an IND unit and included Ms. Laval as a protected occupant. In order number 4624, the Loft Board accepted the withdrawals of the tenants with prejudice pursuant to their respective agreements and dismissed Ms. Laval's coverage claims for her unit as moot based on owner's registration. The Loft Board also deemed the coverage claims for Units 1 and the dormant unit discontinued without prejudice based on the November 23, 2015 email. Tenant argues that the Loft Board deprived tenant of her due process rights when it dismissed her coverage claims for her unit as moot. Staff disagrees. The doctrine of mootness applies where circumstances and events have occurred which result in the elimination of the underlying controversy between the parties. Here, owner registered the Laval unit as an IMD unit, and Ms. Laval as a protected occupant. There is no controversy with respect to the Laval unit. Tenant argues that the Loft Board committed an error of law when it failed to declare the dormant unit an IMD unit based on Judge Spooner's memorandum decision dated June 12, 2015. However, Judge Spooner did not find that the dormant unit qualified for Article 7C coverage. Judge Spooner only found that the dormant unit was residentially occupied for the required time for coverage pursuant to MDL 2815. There was no error of law. Tenant argues that the Loft Board committed an error of law when it discontinued without prejudice the coverage claims for Unit 1 and the dormant unit based on the November 23, 2015 email. Tenant claims that her prior counsel did not represent the tenants in Unit 1 and the dormant unit, and therefore could not discontinue any applications on behalf of the tenants of those units. However, tenant's prior counsel did not discontinue the application on behalf of the tenants in Unit 1 and the dormant unit. The occupants of these units were not applicants in this case. Rather, tenant's prior counsel discontinued the application on behalf of tenant. As the other applicants had already withdrawn their coverage claims with prejudice, tenant's prior counsel had the authority to discontinue the coverage claims for Unit 1 and the dormant unit. Tenant argues that the Loft Board should have declared the Cologne unit an IMD unit based on owner conceding that the Cologne unit met all the requirements for coverage under MDL 2815. Owner may have conceded that the Cologne unit met all requirements for coverage, but owner never agreed to register the Cologne unit. Instead, Theodore Cologne, the tenant, withdrew the coverage claim for his unit with prejudice. Tenant also argues that the Loft Board committed an error of law by issuing the order before owner filed an application registering the Cologne unit and dormant unit as IMD units. Staff disagrees. There is no rule that requires this delay in processing the case. Staff recommends that the board deny the reconsideration application.
Thank you, Mr. Bali. Does anyone have any comments? If you have no comments, do we have a motion to accept this case? Mr. Horowitz, second. Mr. Carter. Thank you. Mr. Rivera, could you please call the board?
Mr. Carver?
Yes.
Mr. Barber?
Yes.
Mr. Rush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 1 absent.
Thank you, Mr. Rivera. There are 9 cases on the summer calendar, usually voted on as a block. However, we will separate out case number 4, Michael Brent and Anwarti Lavette at 53 Pearl Street, Brooklyn, PO 0035, and number 11, Michael Brent and Anwarti Lavette, 53 Pearl Street again, TR 1313 for separate voting. With that in mind, does anyone have any comments about the rest of the cases? The remaining cases, should I read them all? Yes. So the cases that we're going to vote on in the block will be case number 5, Monica Hernandez at 143 to 153 Robbling Street in Brooklyn, PO 0038. Peter and Elizabeth Malerba, 255 18th Street in Brooklyn, TA 0217. Jack and Sylvie Sal, 365 to 369 7th Avenue in Manhattan, TH 0208. Jack and Sylvie Sal at 365 again to 369 7th Avenue, Brooklyn, TN 0226. Case number 9, various tenants of 300 Richardson Street. Address 300 Richardson Street, Brooklyn, TR 1280. Case number 10, Marjorie Nouns. Yes. Coombs. 15 Minetta Street, Manhattan, TR 1307. And finally, Jordan Ring and Elvira Chapova at 85 Chambers Street, Manhattan, TR 1321. Those cases will be voted on as a block. Does anyone have any comments on these cases? There are no comments on the cases. Can we get a motion to accept these cases? Mr. Carver? Second? Mr. Hernandez? Ms. Rivera, could you please?
Mr. Coppel?
Yes.
Mr. Barber?
Yes.
Mr. Bush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Chairperson Henson?
Yeah.
6 in favor, 1 absent.
Thank you, Mr. Rivera. So the second case, these two other cases will be voted on separately. Michael Brent and Anwar T. Lavette, 53 Cross Street, Brooklyn, PO 0035, and same petitioners again, at 53 Cross Street, Brooklyn, TR 1313. Does anyone have any comments on those two cases?
Yes, I'm going to vote against these two cases, even though they're on the summary calendar for withdrawal. Both these cases, one of which is for protected occupancy and the other of which is a coverage request for the same two individuals in the same unit at 53 Pearl Street, suffers from the curious history that the owner registered 3 units, not including the unit in question. And in 2015, the owner allegedly purchased rights in this unit from under 286.12 from someone named Holly Baxter. But in the papers the owner submitted, the owner goes out of his way to claim that the unit in question was not occupied residentially during the window period. So I don't understand how you can purchase rights under 286.12 from someone who's not a registered occupant. I have also learned that the document has still not even been filed, so even though the tenants chose for whatever reason to withdraw their application, there's something about this that's so contrary to what I think we're supposed to be doing at the Loft Board that I'm trying to vote no.
Any other comments? No other comments? Then we have a motion then to accept these cases. Mr. Carver. Second. Mr. Hernandez. Ms. Rivera, could you please vote?
Mr. Coppel?
Yes.
Mr. Barber?
Yes.
Mr. Bush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
No.
Chairperson Henson?
Yes.
5 in favor, 1 against, 1 absent.
Thank you.
Good.
Yes.
Was your name up there?
You voted. You voted.
Oh, all right, sorry. I didn't hear your name. Okay.
Okay, thank you. There are 2 cases remain on the master calendar. The first case is Joe Salvino, Pablo Castro, Veronica Schwartz, Frank Hughes, Julian Asfor, Jean Costello, and 401 wife tenants. The address is 401 Avenue in Brooklyn. The docket numbers are TR 1033 and TR 1158. And the Executive Director, Ms. Balson, will now present this case.
Good afternoon.
Yeah.
No.
Morning.
Oh, good morning. I'm so used to it being in the afternoon. Before I even get to the presentation, I want to note 2 typos in the order. The report and recommendation of Faye Lewis on the very first page was dated May 20th, 2016. And on the second page, the citation for matter of Doris should also be 2016, so those are going to be corrected. This case involves coverage of 6 units and 5 claims of protected occupancy in 2 structures located at 401 Wythe Avenue and 62 South 6th Street. In the record, the units are referred to the Schwartz-Castro unit, the Asfor unit, the Lozani unit, which is also referred to as the Alonzo or the Alfonso unit, the Hughes-Costello unit, Saladino unit, and the Ziegler unit. After motion practice and 13 days of trial, Oath Judge Faye Lewis recommended coverage for all of the units except the Schwartz-Castro unit. She also recommended that Dr. Asfor, Mr. Hughes, and Mr. Saladino be found protected occupants. Staff recommends, as indicated in the proposed order, that the board accept in part and reject in part Judge Lewis's recommendations. First, the order indicates, and the board staff suggests that the board agree that the structure is a horizontal multiple dwelling. The structure has common ownership, a common certificate of occupancy, common utility service through common piping, and there is a load-bearing wall with a sliding fireproof door that connects the two structures. Next, the case involves two issues that the board has never decided before: how to determine if a unit is located in a basement, and what zoning resolution definition of court to use to determine if a unit has a qualifying window. As to whether or not a unit is located in the basement, Loft Board Rule 2-08A4III, found in Title 29 of the Rules of the City of New York, states that a unit may not be located in a basement as defined in Multiple Dwelling Law 4, Subdivision 38. This section defines a basement as a story partly below curb level, but having at least half of its height above curb level. Therefore, to determine if a unit is located in a basement, we need to define the term curb level. Multiple Dwelling Law 4, subsection 33, contains a definition of curb level. However, that section states that the definition only applies for the purpose of measuring the height of any portion of the building. The term height, also defined in the Multiple Dwelling Law, section 4, subdivision 35.A, height is defined as the vertical distance from the curb level to the level of the highest point of the roof beams. Read together, the definitions cannot be used to determine if a loft unit is in a basement. Judge Lewis resolves the issue by turning to the definition of basement found in section 12-10 of the zoning resolution for guidance, because that section also contains information on how to determine curb level. The specific sentence that she talks about is on through lots, the curb level nearest to a story or portion of a story shall be used to determine whether such a story or portion of a story is a basement. Although this isn't, the buildings are not on a through lot, they do actually border on different streets. Based on this definition, Judge Lewis recommends and staff asks that the board find that a unit is located in a basement if the floor elevation in the unit is lower than the curb level of the nearest street. Adopting this definition, the board would find that the Schwartz-Castro unit is located in a basement because the floor elevation in that unit is lower than the curb level of the nearest street, which is South 6th Street. However, the Hughes, Lozani, and Asfor units would not be located in a basement because the floor elevations in those units are higher than the curb level on Wythe Avenue, the street nearest to those units. We note that this construction complies with the remedial nature of the law, which requires the board to construe terms in favor of granting coverage. We next turn to what zoning resolution definition of court to apply. Staff proposes that the board accept Judge Lewis's analysis as to what definition of court contained in zoning resolution to apply to coverage applications. Judge Lewis states that there is no statutory basis for going beyond zoning resolution section 1210, which is the definitional section of the zoning resolution. That section defines a court, an inner court, and an outer court. The definition applicable in this case would be one of the outer court definitions. An outer court is any open area other than a yard or portion thereof, which is unobstructed from its lowest level to the sky, and which, except for one opening upon a front lot line, is bounded by either building walls or building walls and one or more lot lines other than a front lot line. The Lozani and Hughes units have windows that border on an area that meets this definition. Any regulations regarding requirements in a specific zoning district pertain to the issue of legalization and not the issue of coverage. The Lozani and Hughes units also meet all of the other criteria for coverage. Therefore, staff recommends that the board grant coverage to the Lozani and Hughes units. There are a couple of other window issues. The parties stipulated that the Saladino and Ziegler units have windows that meet the eligibility criteria. The board agrees with Judge Lewis's finding that the Hughes and Asfor units have lot line windows that front on a legal rear yard. As to the other eligibility requirements, the staff recommends that the board accept the report and recommendation of Judge Lewis and grant coverage for these units: S4, Lozani, the Hughes-Costello unit, the Saladino unit, and the Ziegler unit. As to protected occupants, Dr. Asfour lived in his unit prior to the effective date of the Loft law. He did not have a lease. He continues in possession of the unit. The staff recommends that the board grant Dr. Asfour protected occupant status pursuant to 29 RCNY 2-09B1 and B2. Ms. Costello is the prime lessee of the Hughes-Costello unit, but she did not reside in the unit on the effective date of the law and has had no association with the unit since 2011. Based on 29 RCNY 2-09B4, staff recommends that the board deny her protected occupancy claim because she did not use the unit as her primary residence. As to Mr. Saladino, Judge Lewis finds that he is a protected occupant of his unit pursuant to 29 RCNY 2-09B1 and 2. However, because Mr. Saladino is the prime lessee of his unit, the analysis of his claim for protected occupancy falls under 29 RCNY 2-09B4. The record establishes he resided in the unit prior to the effective date of the law and continues to use the unit as his primary residence. Therefore, staff recommends that the board find he is a protected occupant pursuant to 29 RCNY 2-09B4. As to Mr. Hughes, Judge Lewis found him to be a protected occupant pursuant to 29 RCNY 2-09B1 and B2, stating that he is in possession of the unit even though he has not resided in the unit since 2012. Staff recommends that the board reject Mr. Hughes' claim. Section 2-09B1 and B2 apply to residential occupants in possession of residential units. However, Mr. Hughes is not a residential occupant of the unit. Since 2012, he has leased the entire unit, including the bedroom that he used to occupy, to other people. The rule that applies to Mr. Hughes is 29 RCNY 2-09B4, which covers both prime lessees, which he is not, and sublessors who are not prime lessees, which he is. 29 RCNY 2-09B4 requires a sublessor who is not a prime lessee to use the unit as a primary residence in order to be a protected occupant. As Mr. Hughes does not reside in the unit, the staff recommends that the board deny his protected occupancy claim. Thank you.
Thank you, Ms. Wilson. Does anyone have any comments? Mr. Carver.
I do. I have several. I think that the legal analysis of the oath judge, as adopted by the staff opinion, is frankly wrong. So the opinion concedes that the MDL definition of basement is the first place to look. But then the opinion goes on to deviate from the MDL because within the definition of basement, it talks about curb level, and looking at the curb level definition in the MDL, that is to be used to determine building height. That is not a reason to deviate from the MDL because our own rule says for our purposes to use the MDL definition. It's our rule, we must abide by our rule, and our rule has the advantage of being consistent with Loft Law Section 281 sub 5, which says to use the zoning resolution to define yard or court, but makes no mention of the zoning resolution to define basement. Nevertheless, the opinion goes on to use the zoning resolution instead of the MDL to define basement. But even assuming for the sake of argument that the zoning resolution should be consulted for this purpose, consulting the zoning resolution does not lead to the conclusion that is drawn by the opinion. The opinion applies that portion of the zoning resolution definition that says to use the curb level nearest to a story to determine whether that story is a basement, but that definition applies only to through lots. The oath judge specifically found that the subject lot is not a through lot. Therefore, this definition under the zoning resolution does not apply. But of course, the zoning resolution should play no role in the analysis. Our rule says to use the MDL, and that's what the opinion should do. A second reason that I believe the analysis is flawed is on the legal window issue. Loft Law Section 281 Sub 5 precludes coverage for a unit without a window that opens onto a street or lawful yard of court. The staff opinion regards any yard of court as enough to qualify a unit for coverage even if it does not meet the width and depth requirements of the zoning resolution, which are the very factors that make a yard or court lawful. A principle of statutory construction is that every word in the statute should be given effect. The staff opinion renders the word lawful meaningless. And for these reasons, I'm going to vote no on this case.
Thank you, Mr. Carver. Anyone else? Yes, Mr. Rowe.
Mr. Chairman, I also have some comments on this this particular case. My esteemed colleague to my right here actually brought up some of the points that support my statement that there really isn't, in my opinion, any definitive evidence of defining a basement. Even the Judge Lewis herself, stated that she recommends comparing floor elevation in each unit. She uses the terminology recommends several times. And although I have the utmost respect for a judge, had she used the word ruled, I would have been much more comfortable with that versus recommends. I intend to vote no based on the fact that the current certificate of occupancy for this property actually considers it a ground floor and not a basement. And therefore, I believe if we take this order as written, that we are, in essence, without greater evidence to the contrary, penalizing the Schwartz-Castro unit as being in a basement when the Department of Buildings, who is sworn by the city to establish those parameters, states very clearly in the existing C of O that it is a ground floor. I intend to vote no based on that.
Can I just ask, why no?
I'm not in favor of penalizing the Schwartz-Castro unit as being considered in a basement, and the other units not being considered in a basement. It's my belief that this is not a basement, and that no hard body of evidence has been supported. But ultimately, my concern is that the judge herself states that she recommends. She did not rule. Had she ruled or been more definitive, I would have been much more comfortable with a different vote. But I think we have to default to the certificate of occupancy on this, which states that this is a ground floor. And as thus, I think that the Schwartz-Castro unit should be protected occupants as well. Did that answer that?
Yeah. I agree with my colleagues. On the other hand, I feel I don't want to punish the other residents of this building. This is the second case that we've had where we had ruled occasionally a no case. And put this thing in limbo until suddenly we were able to resolve it. I don't know whether this thing is going to get resolved unless it goes into the housing court or some other court. So I'm still conflicted on this. Although I agree that I don't want Castro Schwartz to deny coverage of this building, so I think I'm not a problem with that.
Any other comments?
I would just stress that both judge found 5 of the 6 units to be covered. Obviously, Mr. Carver would read things differently to result in a very limited number of units being covered. And Mr. Roche is in favor of a broader coverage. And this highlights the incredibly poor drafting that was done in a chapter amendment that added these exclusionary provisions to Section 281.5 of the Multiple Dwelling Law. And obviously, under the original Loft law, units that were in basements were legalized. Cellars in 281.5, the legislature went out of its way to state that the unit can't be in either a basement or a cellar without providing much guidance. At least in the window issue, they referred to the zoning resolution. Here they're silent. I respect the fire department's view that if they went out, they would look at the C of O and view these as ground floor units. So it seems like we're in a bit of a dilemma. And I guess my question would be, is there a way to reverse the oath judge with regard to the Schwartz-Castro unit?
So just let me, I mean, that is, of course, Paul, but just to clarify, Mr. Roche, the judge's report recommendation is simply that, a recommendation to the board. Correct. So just to clarify that piece. She can. I'm sorry.
She can't rule. She can't write in her decision. She can't say, I rule. She can't do that. She's just making recommendations.
Right. I respect that, but taking that piece of it and adding it to the other pieces, which I just don't feel that, and let me just state that, and a few of my colleagues are well aware of this, I put a tremendous amount of time into trying to make a determination here. I reached out to some experts in the field. I also discussed this with counsel. I understand maybe the judge is limited, but there isn't anything else that's been presented that's concrete enough for me to feel comfortable to go against what the New York City Department of Buildings has ruled as being a ground floor. And I don't feel that, although I'm troubled by the fact that
You mean, just to clarify, you mean by the C of O?
the C of O that's issued by the New York City Department of Buildings, which is who's tasked by law to make these determinations, says it's a ground floor. So I don't even go as far as to support the language when we start talking about basements and cellars, because nobody's convinced me that it's a basement or a cellar. It's the ground floor, as has been determined by the New York City Department of Buildings. And you know, that's my position. I'm troubled by the fact that a no vote is going to affect a handful of units that would otherwise be covered, at least temporarily. But I also don't feel that the Schwartz-Castro unit should take the hit, so to speak, you know, and be the only one that's excluded when the only concrete legal document that's been shown to me is a C of O that states it's a ground floor, which means the whole discussion is a moot point. So I just want to make sure that everybody understands, both my colleagues on the board and those in attendance today, that my position is this is not a basement or a cellar. The fire department in the city of New York is not saying we advocate you living in a basement or a cellar. My position, based on evidence provided and researched over the last 2 months, is this is a ground floor.
Gotcha. All right. It seems that we have different votes against the order for different reasons, and so I'm just going to allow a vote on this. So it seems like it's not going to pass, from what I'm understanding, and therefore it would seem I have 3 already no's. Correct.
Well, my question would be if we amended the order to say that the board looks to the certificate of occupancy issued by the Department of Buildings.
You mean make that decision now, or read it
Yes.
after? Okay, what are the board members, what do you say?
Well, how could we justify using a C of O when our own rule says to look at the definition of basement in the MDL, or as interpreted by the staff?
If it's not an issue, I think that's okay. I mean, if you're looking, if the C of O has already made that determination, would you have to look anywhere else? I think that's going to be still a discussion.
One thing I'd like to just add here is that twice in this very meeting today, our very own Loft Board and its staff has stated that we are awaiting word on the C of O, or we have made a determination based on the C of O. So this is my whole point. How can we sit here in the same meeting and say we are awaiting a determination from the Department of Buildings on the C of O, and we have referred to the C of O, and in a completely other case, we aren't even mentioning the fact that the C of O says that it's the ground floor. I want to add that in there. I think that's an important piece of this puzzle, because somebody that's following this is going to say, well, wait a minute, you guys, you say you refer to the C of O, and then the next breath, you don't even bring up the C of O, but yet the C of O is a major factor in the issue. So again, I just want to be clean about this process.
Okay, good. I think you were making a motion.
Yeah, I would be supportive, and if it would be appropriate in the form of a motion, and just before, this is obviously a very complicated case. As I said in the private meeting, because I'm allowed to say things that I said in the private meeting, a month ago, I give Judge Lewis and the board staff a lot of credit for trying to look through this. And this is not like a real basement. It's, as I pointed out earlier, some of these units, it's the equivalent of the green rug being the curb level and the blue rug being the floor of the unit. This is purely mean-spirited. The amendments that were offered to limit coverage of certain types of units in the expanded loft law as opposed to the original loft law was really a mean-spirited, quickly conjured up, very poorly drafted set of provisions. The fact that the windows refer to the zoning resolution and the basement and cellar don't refer to anything is just, in my mind, more of an example of that. So to that end, if the opinion of the majority of the board is that we should look to the certificate of occupancy, which has been given very serious consideration in other cases, I would make a motion to amend the order to state that we find all 6 units covered based on the Department of Buildings certificate of occupancy, which identifies them as all being ground floor units.
I don't think it's an appropriate motion.
Well, without a second, it's not even a motion.
Well, no, let me just explain. I mean, even if you want to go there, all the board members should have the benefit of the analysis and the research of the staff and being able to talk to them in private session like we do any case. So
I would agree with that. I would agree with that, Mr. Barber. As much as I would like to say I think it'd be nice to put this to bed in a positive way today, I think, again, we have to allow the staff an opportunity to go back and look at things, and just as us as individuals have said, we need to have 30 days to step back, or in this case it may be 60 if we're not going to move on cases in December. We need to have 60 days to step back and make sure that we agree and look to maybe vote on this in January. But I do support your theory. I just don't think we should ramrod it through today.
Well, in that case, I will withdraw my proposed motion.
Okay, actually,
Well, hold on.
yes.
Hold on. This is not the time to get some kind of acknowledgement of the staff and in fact adjudicate this problem. Is the staff willing to do that?
So the staff doesn't adjudicate, the staff drafts the order
Right,
based
all
on
right.
what it thinks.
Bad
If
language,
if
but
the
anyway.
board directs us to redraft the order to say that the C of O is binding, I think that that's legally defensible. It's not illegal to say that. so we're not opposed to doing that.
All right, so if you're not opposed to that, why can't Chuck's motion be seconded and voted on?
Because of Mr. Carver's.
I understand, but so we all have a vote. You can vote the way he wishes, and the rest of us
But
can vote the way we wish.
he doesn't really have an opportunity to make his argument in a proper manner in a spur of the moment situation.
I have a question. Was this issue even raised prior to being here? That was an issue that was raised in
Judge
report?
Judge Lewis discusses it in a report recommendation, yeah.
Well, look, I'm actually not going to oppose Chuck making the motion that if it means we just get the case out of here, it'll go into an Article 78, and rather than hold it up, let's just move it forward. I think that legal analysis, the C of O, is even worse than as drafted now. So I would have no objection to seeing that go forward because I think that it would not survive.
Do you have a second for the Chuck's motion?
I'll reintroduce my motion.
Please,
Yes.
I second.
Mr. Barnes. Okay, do we,
Mr. Carver?
No.
Wait a minute.
So
What are we voting on?
On your motion.
voting on the motion that you made
Right.
to change the report recommendation. Right. Excuse me, the staff's draft decision to include the C of O in that and grant coverage to the
That's what Schwartz.
I think we would draft it to take out the entire basement analysis and just find that the C of O shows it's a ground floor. I think that's the easiest thing to do.
I know we have a motion in a second on the floor, but I really still feel like it would be a cleaner process and fairer to the staff who drafts these orders to redraft the order and then to read it aloud. But
Well, we could take a 15-minute break.
Either way, my vote is not going to change. However, I mean, here we are again talking about hypotheticals. We don't have anything on paper.
I got you, but in the interest of time, and because I think I want to do this, is to go into not executive, but private session right now for like 10 minutes. Is that okay?
Yes.
And could the members of the public please allow us to go into private session for 10 minutes just to discuss this and get a new language for the order and come back in. Is that all right? Okay, thank you. We have a pause in the German. We are back from private session and we're continuing the meeting. We're discussing case number 13, Joe Saladino, Pablo Castro, Veronica Schwartz, Frank Hughes, Julian S4, Jean Costello, and 41 White tenants. The address is 41 White Avenue, Brooklyn. Docket numbers TR1033, TR1158. Earlier we suspended meeting to go into private session to discuss changing the proposed order based on a motion which we will ask Mr. Delaney to repeat.
Yes, my motion is that we revise the proposed order to modify the finding of Judge Lewis, I believe it is, in the report and recommendation, and to acknowledge that the current C of O for these properties recognizes that the units, that these are ground floor units rather than basement units, and that therefore based on the certificate of occupancy and the requirements that we looked at in section 645B3E of the New York City Charter, that it's incumbent on us to find these to be the units in question, the units that were questioned to be ground floor units, and that would also mean making the Schwartz-Castro unit a protected unit and recognize Schwartz and Castro as protected occupants.
Do we have a second? Mr. Horowitz.
Mr. Carver?
Are we going to have an opportunity to speak about that?
That's the motion.
You can't do it after a second.
Well, why was the second taken without the opportunity to speak after the motion was made?
Could you, Mr. Carlos, could you please address?
Well, in which case, Mr. Lady will have to withdraw the motion temporarily.
Then could you control the motion?
Sure.
Motion is withdrawn. Mr. Delaney, could you reintroduce the motion?
I gotta say all that again? Did you all have to listen to it? Can I paraphrase?
It's on the record.
It's on the record, so all you have to do
Thank you.
is
The
say.
motion is back on the record.
that you
Does anyone have any
remove the
comments on
motion.
the motion?
I do. I think that the draft opinion has now gone from bad to worse. It continues to ignore our own rule. It ignores the state statute, the MDL, in favor of a provision of the city charter and a C of O that has no bearing on our issue. So I'll be voting no.
Thank you, Mr. Carver. Any other comment? Is there a second? Mr. Roberts. Mr. Rivera.
Mr. Cover?
No.
Mr. Garber?
Yes.
Mr. Rush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Chairperson Henson?
Yes.
5 in favor, 1 against, 1 absent.
Thank you. This order will be redrafted by the staff to include the contents of the motion and recirculate to the board members before being published. Where are we? Final case on the master calendar is a removal case. It is number 14. Tagged Realty Corp. and Lechon Yu, 163 Bowery in Manhattan, docket number LE0672. Does anyone have any comments on this, about this case?
Yes, I would just note, I think that this is the first time we've formalized the provision that we put into our rules in around, I think, the year 2000. Here, the owner filed for an increase and indicated that it was not waiving its right to a rent adjustment based on the necessary and reasonable cost of obtaining a residential certificate of occupancy. But our rule as currently drafted states that if you want to apply for the costs of code compliance or an additional adjustment beyond the rent guidelines board increase, that you have to do that within, I believe it's 9 months of obtaining the certificate of occupancy. So in this case, while the owner said, I want to keep my option open to seek a pass along for the necessary and reasonable costs of obtaining a residential certificate of occupancy, we're closing that out and saying that you are only entitled to the RGB increase. And I think that's noteworthy, and I'm going to vote yes.
Is there any other comments on this case? No other comments? Is there a motion?
I'll move.
Mr. Delaney, any second?
Second.
Mr. Rhodes. Mr. Rivera, please.
Mr. Cover?
Yes.
Mr. Garber?
Yes.
Mr. Rush?
Yes.
Mr. Hernandez?
Yes.
Mr. Delaney?
Yes.
Chairperson Nelson?
Yes.
6 in favor, 1 absent.
Thank you. This will conclude our November 30th Loft Board meeting. Board members, please sign and hand in your attendance sheets.